For those of you who do not know me, my name is Bill Ziegler. I'm a patient of mesothelioma for the past 14 years. And I'm also on the board of directors, which everybody should know that the foundation is very near and dear to my heart. This afternoon we'll be talking about some legal issues in pertaining to mesothelioma, and this is our legal panel. Thank you for taking the time to join us on our legal panel, the representatives from two of our presenting sponsors, both Belluck Law and MRHFM. We're very glad to have them to help us address some of the major common questions and uncertainties about mesothelioma and the legal process behind it. This session is mostly designed to generally educate you. This is not for specific law cases that you may be undergoing right now, but we do hope that it gives you a clear understanding of what to expect during that process. Please join me in welcoming our two guests, Dawn Besserman from MRHFM and Seth Dymond from Belluck Law. To start out, we are going to do a speed round. The format of this is just going to be standardized questions that we usually get a lot from our patients and families who have been affected. We'll just go through and ask some questions in a Mythbusters style, whether, a Mythbusters type of style, whether it's true or false. Each one of our panelists has a couple different cards there that they can hold up. Okay, so the first question, you can only file in the state where you live now. True or false? Seth, can you expand a little bit on that and tell us a little bit behind your answer?
Sure. So there's a lot of different jurisdictions you may be able to file in. It is not limited to where you currently live. And there's a lot of factors that go into this. One factor could be where you were exposed in other states, where you grew up, where you may have resided. And so when we get a case, we have to look at a lot of different factors. And ultimately, the decision that we make as lawyers is to try and file in a jurisdiction where we believe we're going to be able to viably maintain your case and maximize the value of your case.
Nice. Dawn, is there anything else you'd like to add?
The only thing I'd like to add is, in addition to where you were exposed or where you live, we also look potentially at where the defendants are geographically located, where they're headquartered, where they're incorporated, potentially where they manufactured products. Oftentimes in an individual's case, there may be multiple locations where we can file a case, multiple jurisdictions in which we can file a client's case. And like Seth said, we will do everything we can, your lawyers should do everything they can to put your case in the best jurisdiction where you're going to maximize recovery. And sometimes for some clients that means that we file multiple cases in multiple jurisdictions to make sure that we're able to recover the maximum amount of compensation for you and your family.
Very good. Okay, the next statement. You can't file if the company responds is no longer in existence. Okay, Dawn, we'll start with you.
Sometimes that's true. Sometimes a company that exposed someone goes out of business and there's unfortunately no compensation that we're able to get for the person that was exposed. However, sometimes we are able to still pursue claims even if the company is no longer in existence, particularly where there is insurance proceeds that we may be able to get to. So just because you're aware of an exposure that you had to a product and that company made the product is no longer in existence, that does not mean that you don't have a claim. And this is one of the reasons why it's so important that anyone who is diagnosed with this disease reaches out to a law firm and speaks with an attorney to find out what their options are, because there may be sources of recovery that you simply aren't aware of that still exist.
Seth, anything to add?
I'll add a very legal answer. which is in deciding whether you can sue a dissolved company, the focus is where that company was incorporated. Not where their headquarters were, but where they actually filed papers for incorporation. And that kind of differs wildly between states. In the state we're sitting in, Pennsylvania, you can only sue a company 2 years after dissolution of the company. But in the neighboring state of New Jersey, you can sue a company that's dissolved indefinitely. So that's the first legal determination that we make. But then the second one goes directly to what Dawn was speaking of. It's, if they're dissolved, we know they have no assets. We know they have nothing to really pay. But if there's insurance we can find, we have various ways we go about, from an archaeological standpoint, looking for insurance. If we can find that insurance, then we're going to sue the company if they are amenable to suit in the state in which they were incorporated.
Okay. Next statement, something I hear quite frequently. Filing a claim could affect your current medical or VA benefits. Dawn?
False. Filing a claim will not affect your medical benefits. It will not affect your VA benefits.
Okay. Anything else you'd like to add, Seth?
It's as simple as that.
Okay, perfect. If the exposure happens decades ago, is it too late to file? Okay, Dawn, you had a different answer. It depends. Tell us a little bit about why you answered it depends.
Well, the situation is, generally it is false. Yes, we can pursue, I mean, look, if you have mesothelioma, you were exposed to asbestos, that exposure happened at least 10 years ago if it's compensable. So we're stuck going back and looking at exposures that happened decades ago. Now, this kind of dovetails back to the question, the previous question about if a company is no longer in existence. If that was your only exposure, there is no company that we can go after, then really there is no case to file. But really what determines when you can file a lawsuit is the date of diagnosis, and that's really what triggers the statute of limitations and determines when you can file a lawsuit.
Okay. Seth, anything different?
And I will, again, add a very legalese type of response on top of that. And this kind of shows you how interrelated a lot of these questions are, because this goes back to another Mythbuster question that we were asked earlier, which is there are certain jurisdictions that have certain laws that say, okay, well, if you're trying to sue a boiler company or something, or a premise owner, it can only be 10 years after the exposure. So that is a factor we take into account in deciding what jurisdiction we're filing, because we know if we're filing in a jurisdiction that has a law like that, it's going to be problematic if you know that you were exposed to, ABC defendants in that jurisdiction.
Okay, move it.
Oh, I was just going to add, what Seth is talking about is what lawyers refer to as statutes of repose, which do limit claims that we can make for some clients. But the fact that, these answers that we're giving you are so hyper technical and dependent on laws of various states is exactly why it's so important that when you or your loved one is diagnosed, that you reach out and talk to a law firm so that you can go through this analysis with someone who is an expert in the law that is applicable to you and your claim, and make a determination as to what claims can be pursued for you.
And that's a really good segue, because the next statement is, if you're a patient, you can take your time contacting an attorney after diagnosis. Both said false. Seth, I'll let you answer on this.
Right, so that's another legal term that probably a lot of you have heard of, which is the statute of limitations. And that says, generally speaking, it says once you've been injured and you are filing in a jurisdiction, you can pick one, you have X number of years to file that claim. That also differs from jurisdiction to jurisdiction. For our purposes, we have something that's really good that a lot of legislatures have passed. That's a discovery rule. That means you're not limited to, for example, 2 or 3 years to file after you were exposed, which technically could be when you were injured or began to be injured from a cellular level. But you have 2 or 3 years from when it was discovered. That means either when you first started having symptoms or when you were diagnosed. And that's why we are permitted to pursue claims for exposures to asbestos that occurred 20, 30, 40, 50 years ago.
Dawn, anything you'd like to add on?
Sure. In addition to the statutes of limitation, which do vary from state to state, most of them fall within that 2 to 3 range. Some are less than that. So it is important that you do reach out soon after diagnosis, because diagnosis is generally what triggers the statutes of limitation. But even, setting aside the statutes of limitations concerns, the reality is that mesothelioma can be a very aggressive disease, and persons that are diagnosed often just do not stay healthy enough, long enough to provide the evidence that is needed if they wait too long for legal help. So you can't take for granted your health and how your disease is going to progress and how that may potentially affect the ability to preserve your testimony or statements concerning your exposure. Sometimes, unfortunately, the only evidence of a person's exposure is from that person themselves. So if we can get that evidence early and preserve it either through affidavits or deposition testimony, that can be very, very critical to the overall success of a person's case.
Yeah, and I'll just add one thing on that. A lot of the laws that we have in place allow us to kind of expedite these processes once we file your claim. So we normally can get you into a deposition very quickly, but you have to come to us first in a timely manner after your diagnosis in order for that to happen.
Okay, thank you. Next statement. If you don't know exactly where your exposure happened, you can't file a claim. Okay, Seth, I'll let you take this one.
Yeah, and that's another thing that I think the lawyers tend to be experts in. A lot of times people don't know where they were exposed, when they were exposed, and as I think most of you know, exposures have occurred decades ago, sometimes half a century ago. So what we do as lawyers is we're able to kind of do what's called in history. It's an occupational history, it's a history of your residences, and we're able to kind of determine from that where you may or may not have been exposed and who may be liable for those exposures. So the fact that your exposures happened a long time ago is not a barrier to a lawsuit, and I think that's part of what we touched upon earlier, which is there are things in place like these discovery rules. Say once you're diagnosed, that's when the clock starts ticking for you to file a lawsuit.
Dawn, anything to add?
I would just add that the law firm that you hire to prosecute your claims should be an expert in developing the evidence needed to determine what your exposures were and go after the companies that were responsible for those exposures. Most of the time, our clients don't know any of their exposures or all of their exposures. Much of the evidence comes out through the investigation and work with the law firm. Usually there's an attorney and an investigator involved, a whole team of people that are dedicated to going through your personal history and making a determination as to what all of your potential exposures were during your lifetime.
Okay. Now, if you have mesothelioma, you automatically have a strong case?
No. That would be false.
Okay. Seth, why is that?
Well, that goes back again to the idea of where did your exposure come from, and do we have viable entities that we can pursue for that exposure once we've teased out all the potential history that you may have had. So maybe the company's dissolved. Maybe there's other reasons that they're not suable. So the fact that you're diagnosed, unfortunately, does not give you an automatic good case. But the only kind of way to figure that out is to meet with the lawyers so we can kind of drill down on where we believe the history of exposure may have come from.
Okay, Dawn, can you expound?
Sure. You know, this goes back to the importance of reaching out early on after your diagnosis and retaining a law firm that you trust to handle your claims so that they can fully investigate all of your potential exposures. Sometimes it unfortunately is the case that a person doesn't have a strong case as to many defendants. And that's an unfortunate situation, but the law firm that you retain should be an expert in these type of claims and should do a very full and thorough analysis to rule out any source of potential recovery. And for most folks, there is some recovery.
Okay. Next statement. You'll owe a large portion of any compensation in taxes. Okay, Seth, tell me a little bit about your answer.
So I'll start by saying this. Please don't take financial advice from your lawyers. We should not be giving you financial advice in that regard. You should always seek out an accountant or a financial advisor for that type of information. I will say generally, under federal law, a lot of your recovery is not going to be taxable. State, that may not be the case, so that's one reason to seek out an accountant for that type of information. And then it also depends on the type of damages recovery that is applicable to your case. So when we're talking about something like pain and suffering, those are non-economic damages. Those tend to not be taxable for the most part. Not giving advice, please, but economic loss. So if you would have worked for another 8 years and you have lost income, for example, it's possible that that may be taxable, and that's why we always advise to seek out an accountant or a financial advisor for that type of determination.
Dawn?
I would just add, I echo Seth's admonishment not to take tax advice from someone who is not a tax professional. But I will tell you that for the vast majority of clients, the recovery that you receive is not taxable. It is generally reserved only for lost wages claims, like Seth mentioned. Your pain and suffering damages and the damages related to your medical care and treatment are not taxable.
Okay, thank you. My loved one did not want to file a claim, and they passed away, so it's too late to seek compensation now. Okay, Dawn, can you tell us about your answer?
Hold up both at the same time.
Sure. Generally, when someone passes away, then the only claim that is available to be pursued is a wrongful death case. And the wrongful death case statute of limitations begins to run when the person dies, which means that the family members still can pursue a wrongful death claim so long as they do so within the statute of limitations in the states, within the state where the case will be filed.
Yeah, and I think you're somewhat noticing a theme here, which is that the importance of deciding which jurisdiction to file a lawsuit in is perhaps the most critical thing that happens in a lawsuit, because that triggers a lot of other determinations as to what can and cannot be pursued and who not can be pursued as defendants.
Okay. Thank you for participating in that Mythbusters style true-false answer question. To kind of push the conversation forward, I want to walk through a fictional but common scenario that we typically face in the meso community. I'll set up the scenario as such. My loved one was diagnosed with mesothelioma about 5 months ago. They're currently in active treatment, and we're ready to meet with a law firm to explore some legal options. We don't know where the exposure occurred, and we've lived in 3 different states. So question number 1, how should we start looking for a law firm? Should we stay local, or does it make sense to work with a firm in a different state that may have been more focused on exposure and have a national connection?
So my personal opinion is that the very best thing to do, the best way to find a lawyer is by word of mouth. Reach out to see if you know anyone who's used lawyers in this realm. If they have friends, if your family has other friends, I think use your network of family and friends to see if there's word of mouth recommendations. I think that's probably the best way. But of course, it's important for you to kind of do your research. There's a lot of stuff online that you can use, including this foundation, to kind of point you in certain directions. And I think that that's a helpful tool, but I would not completely rely if you can avoid it on the internet.
Dawn?
I disagree with Seth primarily on this point. It's my opinion that when you are faced with a diagnosis like this, it is one of the most horrifying moments of your life and your family's life. And these cases are extraordinarily important. They're very sad. The damages are as bad as it gets because we're dealing with life and death. And in that circumstance, you want a law firm that knows what it's doing. You want a law firm that focuses on this disease and these types of cases. I would not encourage asking friends or family or going to your local small town attorney's office and asking for a recommendation. You need to do your research, and you need to find a law firm that's an expert in this field. You are likely going to be facing on the other side of the claims that you're making, large corporations that have extensive resources in funding the litigation and opposing your claims, and you want the best, most well-qualified and well-resourced law firm that you can find to support you and pursue your claims for you.
And I'll just say by word of mouth, that's not asking your family, if they've had a slip and fall on the sidewalk and who do they use. It's injuries in this realm. Because people are going to be able to tell you they had a good or bad experience if you're able to find someone, if they had a good or bad experience with a particular law firm. So you can either put someone on your list or you can eliminate someone from your list by doing that. And those are really invaluable types of tools that you don't necessarily get online. And you don't want to be, given expectations by what you see online. If you see some massive verdict, that's not to say that you're going to have a recovery in that same realm. So it's a great tool to use, just be wary. That's my personal opinion.
Thank you for your answers. My loved one is in active treatment. What kind of commitment does this process usually require from them or from me as a caregiver? Oh, well, that's the statement here. My loved one's in active treatment. What kind of commitment does this take in terms of time from both me or my caregiver?
That's a good question, and I know that that's something that patients commonly want to know from the outset because they are overwhelmed with the medical diagnosis and the treatment that they are going to be undergoing, and there's a lot of trepidation about venturing into the legal side of things so early on following diagnosis. We recognize that the firms that are serious in representing people in this very niche litigation all recognize that the most important thing for our clients is their medical care and treatment, and that is their number one focus. Legal is secondary to medical. it's important, as we've been discussing, it's important to pursue it early and thoroughly. But yes, your medical care and treatment comes first. Any law firm that you hire will work with you around your medical treatment schedule and will recognize that medical comes first. And I can't stress that enough. If you have trepidation about pursuing the legal, the firm that you hire should work with you in making sure that it's least burdensome on you as possible. Now, of course, there is some time commitment involved from the client and the family, and there are ways that we can work with you to keep that burden as minimal as possible, but there is a time commitment. You should expect that when you hire a law firm, they will come to you. You not have to leave your house to go to meetings or go to a law firm's office. The lawyer should come to your house at times when it's convenient for you, when you're feeling up to visitors and talking with visitors, and they will work with you to make sure that the legal side of things is not a burden.
Yeah, and no one should feel like they are in this process but don't have an actual input into how this process proceeds. That includes with your time and how much time you're giving and when you're giving it. If there's an instance where you're on a track where you say, look, I don't want to deal with the trial, I don't want to go to trial, fine. Then your time commitment is altered slightly in that case, and it's your lawyer's job to deal with that and still maximize your recovery in that circumstance. So just be aware that you should demand that you have input in this process.
What kind of questions will the firm ask to determine where the exposure might have happened and whether they have a case? Dawn?
Thanks.
Yeah.
It's hard sitting here to know who you're directing the question to.
Yeah, especially when you both look at me. Yeah.
That's right. That's
Next time I'll call you out.
No, you should expect that when you first meet with your lawyer, they're going to walk through your life history with you. And unfortunately, we start from the very beginning. Where were you born? And we walk through who you lived with growing up, what your parents did, what your siblings did, what your first occupation was, all the way through up until your diagnosis. And we'll talk to you about your occupational history, the occupational history of anyone who lived in any home with you. We'll talk to you about non-occupational ways you may have been exposed, either through home remodeling, talcum powder usage, automotive repairs, other hobbies that may have exposed you to asbestos. And we will go through your entire life and try to uncover every potential source of exposure, because the reality is that every source of exposure to asbestos that you had is a potential source of compensation recovery for you and your family.
Is that anything you want to add?
Yeah, I think generally there's categories of exposures, and we kind of get into the very nitty-gritty details of all these. Occupational, it seems to be very obvious. Para-occupational, which is occupational type exposures that are not really involved with your job, and Dawn mentioned kind of home renovations. That's one example. There's consumer products that you may have used. There's environmental neighborhood exposures. You may not have noticed, but perhaps when you were 10 years old, you lived within half a mile of a factory that was using asbestos, or a mine that was mining either asbestos or talc, which may have been contaminated with asbestos. And there's take-home type exposures, which means someone's working with it, a spouse, a father, a mother, and it's on their clothes, and when they come home, you are exposed from their clothing. So we have ways of getting to the bottom of all of this, but it is kind of an extensive process, but this is kind of what we as lawyers in this field excel at, and that's where we get to the bottom of finding compensation for you.
Okay, I want to open it up to the floor for any questions in this first phase of getting started with your attorney. Does anybody have questions? Is anything confusing or overwhelming? We want to make sure that we clear things up. She's going to, there's a microphone for you.
My question is the difference between, you mentioned lawsuit, but what about the bankruptcy settlement types of claims?
I think we have that question coming up, but I'll answer
absolutely.
it. I'll happily answer it. And I'll give you a very small history lesson to do that. Some of you may have heard the name Johns Manville before. This was a corporation that dealt heavily in asbestos for a very long time, probably a century. And when claims started to get filed against Johns Manville, they decided, kind of naturally and not unexpected, that they were going to file for bankruptcy. And this was a massive company with a lot of assets, and everyone essentially said, we just can't let this happen. We need to do something about this. So Congress stepped in and amended the bankruptcy code to create a provision where companies in this realm that are in asbestos and have a lot of claims filed against them and have a lot of money, that they are forced to put money into a trust fund. And the idea of this is that this is a fund that is, or a trust that is going to be able to give money to people that currently have claims and people that in the future may have claims in which this defendant, Johns Manville, is implicated. And this law obviously is intended not just for Johns Manville, but for any other company in the asbestos world that filed for bankruptcy. So all of those claims get channeled to the trust. And the trust has someone who invests the money, so there's still money there for future claimants. And what we do as lawyers is we file what's called proof of claim forms with the trust themselves. This is outside of the tort system. And we have to prove certain things, fill out certain information, and the trust come back and say, okay, we are going to give you compensation. Now, the one caveat to this is, and you may have seen certain advertisements on TV that say, well, there's this amount of billions of dollars in trusts. So here's kind of the caveat and the problem with this is because this is through a bankruptcy, if you're getting a settlement, you're not getting a dollar for dollar settlement. It's unfortunate, but that's just the way it works because if their intent is to keep money in the trust so future people can also be compensated, then they're not going to pay you $1 for every dollar of settlement. So each trust kind of has a different formula, but none of them are very good. We're talking 10 cents on the dollar. Some of them are 2 or 3 cents on the dollar. And that tends to vary slightly year by year, depending on how well the trusts continue to do. But that's the mechanism of compensation for these trusts. And it is an additional means of recovery that your lawyers can help you get beyond the tort system.
Any other questions? Yes, in the back. What determines whether you settle or go to trial?
That's a great question. There are a lot of factors that go into that analysis, but at the end of the day, if your law firm decides that there's sufficient evidence to file a claim in civil court on your behalf, and they pursue claims for you in civil court, and you proceed in the litigation up to the ultimate goal of going to trial, at the end of the day, the decision as to whether that case goes to trial or not is really the client's ultimate decision. Your lawyers are going to advise you as to whether they believe that your case should proceed to trial or should settle if the defendant is offering money. And that's an if the defendant is offering money. They don't always offer money prior to trial. But if a settlement offer is made, then you and your counsel will sit down together and look at the risks and benefits of proceeding to trial, and then ultimately, while your attorney will advise you, the client is the ultimate decision maker when it comes to that. And just to kind of step back a little bit, going back, this kind of dovetails with the question about the different trusts that have been established. We should probably take a step back and explain for people that don't have familiarity with the different types of compensation that are available. Generally, for a mesothelioma victim, there are at least 3 potential sources of recovery for a client. If you served in the military and you had exposures to asbestos during your military service, there is the potential that you can pursue Veterans Administration benefits. If you don't have a military history, then typically what we're looking at is either the civil claims that we've been talking about, and those are claims that you file in the civil court system against companies that we refer to as solvent companies. Those are companies that generally are still in existence, or dissolved companies that, like we were talking about earlier, that can still be sued and have insurance assets. And then the third potential source of recovery is through the trust claims system, and that's reserved for the trusts that have been established through this 524G system that Seth was just talking about. And that is when companies that have a significant asbestos liabilities file for bankruptcy protection, and a trust is established related to the products for which that company is responsible. For many claimants, many victims, you may have multiple sources of recovery. You may have served in the military, you may have been exposed to solvent products manufactured by defendants that can be pursued in the civil court, and you may also have been exposed to products that are subject to the bankruptcy trust claims process. So there are multiple sources of recovery potentially for a client, and most clients have a mixture of both trust claims and solvent claims. And the trust claims are claims that never go to trial. Those aren't through the court system. Those are through a whole different administrative process. But the claims that we can pursue for you in civil court, those are the ones that could potentially go to trial. And ultimately, the decision as to whether your case is going to proceed to trial is going to be dependent on a lot of factors regarding the evidence, the defendant at issue, what they're offering, what the strength of your evidence is against that company, and then you, as the client, ultimately make the decision as to whether to proceed to trial or accept a settlement offer.
Last one gives you an idea, advice as to whether you should proceed or not.
Absolutely.
So I'm going to reopen the floor in a little bit to some further questions, but I want to go back to the attorney and client relationship. Let's pretend that they're sitting down together, they're building a case, they're understanding where maybe exposures came from, and we talked a little bit about the process overall to identify either these companies or the questions that you're going to ask the client to be able to identify. But does the process differ from maybe where the exposure came from, like a consumer product or even versus a workplace exposure? Is there any variance in the process to identify or even receive compensation from those areas?
I don't think the process, so to speak, differs too much depending on what type of exposure is. What may differ is how we build the case out, because in certain types of claims involving certain types of products, we may need additional evidence in the form of an additional expert that we wouldn't necessarily use in another case. So it's a factor in the sense that there may be an added expense involved in the case because we have an additional element that needs to be established, and this is the expert or type of expert that we need to do that. But generally, the process is going to be the same, especially as to identification of kind of what type of exposure or exposures you may have had.
Dawn, anything you'd like to add?
I would just add to what Seth was just saying. Yes, the investigative process itself is generally the same across the board. We're going to employ the same investigative techniques regardless of the type of exposures at issue, because we want to try to capture all of the exposures. The process in terms of the legal process, once we make a determination as to what claims we can pursue, can vary, and that's going to depend on whether we're pursuing trust claims, solvent claims, a mixture of both, whether we have solvent claims that we have to pursue in multiple states and multiple jurisdictions, where there may be different timelines at issue, different legal requirements in terms of experts, things of that nature.
Okay. What is a deposition and who usually gives one? Is it done remote? Is it done in person? Tell us a little bit about that process. Dawn, I'll let you go from there.
Sure. A deposition is essentially sworn testimony that is taken to preserve evidence that can be used either in a civil claim. Generally, you're going to be giving a deposition if a civil litigation claim has been filed on your behalf, but the deposition testimony that you give in that case can also be used to support claims that are later filed in the trust claims process. But essentially what a deposition is, it's sworn testimony by you given under oath, just like you were in court, but the deposition never takes place in court. It can take place in a local conference room, at a hotel. It can take place in your home if you're unable or unwilling to travel outside of your home. Generally, the deposition can be made to be as comfortable as possible in terms of location for the client. I would say as far as remote versus in person, that really does vary depending on the requirements of the court where the case is pending. But generally, most of the time, we can get at least a component of the deposition to be remote, so that not every attorney is in the room asking questions of the witness at that time. And in some circumstances, we can do a deposition fully remote so that the client is at home at their kitchen table with a laptop and a video screen in front of them, so that they can answer and questions that are posed to them from attorneys that are located anywhere outside of their home, essentially.
Seth, anything you'd like to add?
I think the first real significant thing that happens in your case is a discovery deposition. It's referred to as a discovery deposition because the intent is to allow the defendants that are in the case to discover what it is you know about their particular products, or what it is you may not know about their particular products. And this goes back to kind of the significance of the lawyers that you choose, because you want someone with you during that deposition who's going to be able to manage the defendant's questioning. And there are a lot of instances, for example, when the defendants don't ask questions to discover anything that they should be asking. And so it's your lawyer's job to be able to protect you in that regard, to get that information to come to light during the discovery deposition by their own kind of examination of you towards the end. And as far as where it occurs, it does kind of vary, but the pandemic changed a lot of things, some for good, some not so much, but I think the remote aspect of depositions is a benefit that came out of the pandemic. Typically in our cases, they're almost all in your home with our lawyer there and no defendants there. The defendant's counsel typically are remote. There are certain instances where some defense counsel demands to be present, but generally I think it's a much more comfortable experience when you're in your own home and you're not surrounded by 30 defense lawyers.
Okay, if I'm a client, at what point will I know whether my case is headed for a settlement or a trial? And what's more common, and how can I prepare for both? Seth?
So most of these cases wind up resolving. Most of them wind up settling. Very few actually go to trial. And when they do, a lot of the claims have already been settled. So we're sitting there at trial with maybe one or two defendants that we're trying to pursue, and even then, active settlement discussions are occurring. In most of these cases, we also have scheduling orders that we go by. So we know from very early after commencement of your lawsuit what the trial date is going to be. And that's really the basis for what both parties use to try and either discuss settlement or proceed to trial. And I think as far as when it happens, most of them don't happen at the outset, right? Because the defendants want to kind of figure out, are they really in the case? Is there any holes they can poke in it? And so when we get closer to trial, that's when it starts to get very real for defendants, when they're expending more costs, and when their risk becomes significant if they have to defend at trial. And that's when a lot of the settlements occur. But your lawyer should really be in communication with you throughout this entire process, so you know for certain whether these defendants are likely to settle or whether this one's likely to go to trial or whatever the particular circumstance of your case may be.
Dawn?
Sure. With most clients, we find that they have had exposures to asbestos from a multitude of sources. And accordingly, in most cases, there are going to be multiple defendants named in the case. And in these cases, generally, settlements occur throughout the life of the case as to each particular defendant. So in a case like this, you're going to have settlements that occur throughout the life of the case leading up to the trial. And as Seth mentioned, in any jurisdiction, you're going to be given a discovery and scheduling order with a trial date that kind of sets in motion various deadlines and a basic timeline for your case. But you should be expecting that you're likely going to be in communication with your attorney regularly throughout this entire process, and that your attorney is going to be updating you with settlement offers from multiple defendants throughout the case. So the reality is you should be receiving generally settlements throughout the lifetime of your case leading up to trial, and if it looks like there will potentially be a trial as to one or more of the defendants, you will be in communications with your attorney along the way so that you have an understanding and an appreciation as to the likelihood that various claims may need to go all the way through trial. But again, it's a process, and most of the time you're going to be receiving settlements throughout that process. And of course, it's critical that your attorney remains in regular communication with you so that you have an understanding as to what to expect each step of the way and as to each defendant in the case.
Now, with that said, let's say there is good news on the case and a case goes to settlement. How long should it take from that time the case is settled to receiving a payment?
So for each claim, right, we have a settlement for each claim. It's very rare that you're going to have an asbestos case filed and everything settles at once. Like I said, it's a process that happens as to each defendant independently and separately. Each time you agree to settle a claim with a defendant, of course that's an important milestone in the case when you reach that settlement agreement, but that is not the end of the process with respect to that defendant. There is a process that follows the settlement agreement, and that is a process which involves release paperwork, settlement release paperwork, negotiations between your attorney and the defendant's attorney about all of the legalese that's used in the release papers. Once that is agreed to, then there is a time where you get sent the release, you get to review it. You may have questions about the release and talk to your attorney, and then you sign it, you notarize it, you mail it back, it goes to your attorney's office, then they send it to the defense, and then it takes a period of time, usually 60 to 90 days after they receive the signed release before they send to the check. So there is a process, but I would say generally within a few months you should actually expect to see a check in your mail to you that represents your share of the proceeds from that settlement. But again, important milestone when you reach a settlement, but there is a process that follows that agreement.
Seth,
Yeah,
anything?
and there's some small instances where a particular settlement may need court approval. It may be the court we're dealing with. It may be a different court, like the surrogates court, before we can kind of issue the distribution of payment to you. But all of this should be something that we're in full communication about regarding that timeline and where everything sits.
Okay. Let's say the client or my loved one who I'm caring for is on Medicare. Are there any reimbursements that I need to make to them for covered health care?
So if you are on Medicare, the Congress in 1980 amended the Medicare Act. And so what that basically did was if you have exposure that goes beyond 1980, you may be subject to certain Medicare liens. And what we do, our law offices, is we have people that if we see you have a lien and we have a settlement from some defendant or multiple defendants, we start negotiating with Medicare to get those liens down. And we've been very successful, and I'm sure Dawn's office has too, has been very successful in negotiating to kind of reduce the value of liens. And all of that, of course, is done to kind of maximize the amount of recovery and compensation we can get to you without giving you something and saying, well, listen, here's this portion that we're taking out because we have to pay Medicare.
Okay. Dawn, anything you want to add?
I would just add that, again, it's very distinct to each particular settlement at issue. So, for instance, as I was saying earlier, most clients have exposures to different products throughout their lifetime. If you settle with one defendant whose exposure, to whose product you were exposed prior to 1980, December 5th, 1980, and all of the exposure to that defendant's products occurred prior to that date, then Medicare won't have a subrogation interest. It's only if your exposure to a particular defendant's products goes beyond that December 5th, 1980 deadline, I guess, where Medicare then has a subrogation right. And your law firm should be able to negotiate that Medicare lien, if it exists, down significantly from what Medicare initially requests.
Okay, other question I have for you is what portion of the settlement typically goes to legal fees? Do those percentages usually change between firms? And are there any costs that I should expect other than legal fees?
Yes, so in addition to potential Medicare subrogation liens, there could potentially be liens from private health insurance, and that varies from health insurance to health insurance company as well as state to state. So that is a whole nother series of issues that could arise in your case, and it's so fact dependent based on who your health insurance carrier is, what state you live in, what state your case is filed in. There is a potential, though, for health insurance liens. Of course, your law firm's attorney's fees will come out of the settlements. I would expect that any law firm that you are in discussions with to represent you will present you with a contingent fee agreement wherein they are paid out of a settlement only, and they are only paid if they obtain recovery for you, such that you're never billed by your law firm, you're never writing a check to your law firm. They're only getting paid if they're successful in obtaining recovery for you. And in terms of attorney's fees, that can vary from jurisdiction to jurisdiction. There are some jurisdictions like New York or New Jersey or Florida that have very specific guidelines and requirements as to what attorneys can charge. There are some trusts that limit attorneys' fees and set forth what the attorney's fees can be. So there is definitely a variance in the fees that can be paid from law firm to law firm and state to state.
Yeah, and as far as the costs are concerned, that's typically going to vary on what jurisdiction as well, because different jurisdictions have different standards of proof that you have to meet. In one jurisdiction, you may need to only use 2 experts, for example, for your case, but in another jurisdiction, you may need 6. And that also depends on what type of claim you have. Is it a purely occupational claim, or is it a cosmetic product use claim? That also would be determinant of the number of experts. Generally, because the cases are highly complex as to the science and the medicine, we have to have experts to be able to prove our case. And that's really where the brunt of the cost comes in. But as Dawn mentioned, none of that cost is borne by you out of pocket. It's a cost recouped from the settlements when the settlements are made.
Okay. Let's move on and say that the case that the client has moves on, or the offer that came in for a settlement value was just too low, and now the case is heading towards trial. Roughly how long does it take from collecting depositions to finishing the trial? Or the process of that?
It's going to vary wildly from jurisdiction to jurisdiction. There are some jurisdictions where we can file, where we know that we can expedite this process, and we can get you into a trial, if in fact we are proceeding to trial, within an 11 or 12 month period. Other jurisdictions, it takes a lot longer, and this really is just one of the factors that we take into account, especially considering your health status, how you are feeling. We want everyone to be there throughout the entirety of this trial, and to ensure that you see this to its finality. So those are just kind of considerations that we take into account. But hopefully it's as short as possible, and our goal is always to get you there as quickly as possible.
Okay, I want to finish up because we're running low on time here, but will my loved one need to appear in court should it go to trial?
That's a good question. It depends on the case and the trial, but for the most part, if the client is not medically able to testify or travel to trial, they don't have to. It's not a requirement that the mesothelioma victim or patient actually appear at trial. Sometimes your lawyer is going to counsel you that they want you to be there because the importance of the impact that you may make in front of a jury. But at the end of the day, if you can't or absolutely don't want to be in a courtroom, that is usually something that can be accommodated in your case. And that the fact that you don't want to appear in trial should not prevent you from contacting an attorney to discuss your legal rights and the potential recoveries that they can get from you.
Okay, we're running low on time. I do want to thank our panelists here. Again, we have Dawn Besserman and Seth Dymond. They are going to be available in the rotunda over there should you have any follow-up questions. I would suggest any questions that you do have, please reach out to them. This workshop, I know it might have raised some new questions for you. That's obviously what we're here for, to help everybody have resources in their back pocket. Our third presenting sponsor, Dean, Omar, Brennan, Shirley, Dobbs, as well as the Gorey Law Firm is also available, and they have booths outside as well. They're all here to answer any questions and offer guidance should you need some. Thank you again for spending time with us today, and we'll move it over and hand it back to you. All right, thanks.